We're really, really pleased that we managed to squeeze a day into the timetable of Advocate General Eleanor Sharpston, who's going to give the distinguished lecture today. It's the first time that she's lectured at the Academy, but I hope it won't be the last. Eleanor, I've known Eleanor for some years now.
That's
I think.
polite.
We go
about
back
40.
Some time. And in fact, she's been at the court since 2006, which was the year that I came here to Florence, so we share that. And before that, she was a practicing barrister in the UK, in London, and had been a lecturer, or has been a lecturer in Cambridge, and a fellow of King's College, Cambridge. So she combines the academic side of European law with practice at the bar, and I think you can see both sides of that in her work as Advocate General. Her opinions are always, as I guess many of you are already have had experience of reading her opinions over the years, they're always incredibly readable, but also very lucid. They take you by the hand through the arguments, and when you get to the end, you can't imagine that you would ever have come to a different conclusion, which must be one of the best qualifications for an Advocate General, I think, at the court. Anyway, I'm not going to take any longer in introducing her, because I know that you want to hear what Advocate General Sharpston has to say. She's going to talk to us about refugees, the geography of Europe, and the Dublin III regulation, and I'm really looking forward to hearing what you have to say about that, Eleanor. Thank you.
Dear. Dear Professor Cremona, dear Marise, thank you very much for that kind introduction. The nice things you say about the opinions, I should say at once, are a compliment which I will take not purely for myself. On the contrary, I will take it for the team which is with me and works with me, because it is a collective team effort to produce opinions. I know my name's on the bottom, but it's a team who work with me who ensure the quality of it, and to the extent that they are thoughtful, then some of the credit for that really does go to the team, and I'd like to make that very clear. At the moment, if you pick up the newspapers in the United Kingdom, they are obsessing about Brexit. It would seem that there is no other conceivable topic involving the European Union which might attract anyone's attention. You know, what is the UK's future position? Hard, soft, medium, out entirely, sunlit uplands, whatever. And what are the European partners thinking about Brexit? Are they crying into their teacups that the United Kingdom is going to leave? Are they, on the contrary, ganging up on the United Kingdom vindictively, nastily, to get the worst possible deal in place, or what? Huh? Well, here is a shocking statement from somebody who you can tell from the accent can only be British. There are much more important issues for the European Union than Brexit. The first 60 years of what is called, in shorthand, the European project, have been immensely successful. They have brought peace, above all peace, but also economic prosperity to the continent of Europe. And that is an enormous achievement. There was a massive expansion after the demise of communism in the 2004 accessions, 10 member states, 2009, another 2, 2013, Croatia joins. Unquestionably the right response, historically. Unquestionably the right thing to do. There is a richer and more diverse European Union in consequence. Also a much more complicated European Union. And then, of course, we all know there was the 2009 crisis. Perhaps the motor stalled a little bit. Paradoxically, all the Brexit saga may, in fact, end up by strengthening the EU and by giving us a European Union with a clearer sense of purpose and mission. And I hope so very much, because I am a European. And so there's a lot on the planning sheet. There's a lot that needs to be done for European citizens. More clarity, more transparency, more communication, integrating the younger generation of Europeans into the project, convincing them of the worth of what's happened and what needs to happen, harnessing their dynamism, harnessing their talents. Many, many things that need to be done to take the project forward. And the more successful this is, the more the European Union will act as a magnet for those from less fortunate regions of the world. That seems to me just to be a simple reality. If the European Union is doing well and is prosperous and is peaceful and is stable, those who are in other areas which are not so blessed, other areas where there is strife, other areas where there is not economic prosperity, those people will look, modern communications, the world is not isolated, people know what's going on. People get messages home from people who have already moved. Look, make the move, it's not easy, but. So the more successful the EU project is, the more the EU is going to act as a magnet. And there's a lot of talk that puts together migrants. Actually, it's a term that shouldn't be thrown around because there are all sorts of different reasons why people move. People move because they need international protection, because they are in a place where they fear for their lives and their families' lives, and they need international protection. 1951 Geneva Convention and all of that. People also move because there are things like famines. There are things like economic situations that are so desperate that the only sensible thing to do is to try and get out of there and go somewhere else to make a living for yourself, to build a future for your family, for your children. And yes, there are also economic migrants. It's not a dirty word. There are people who think that they will make more success of their lives economically if they move somewhere else. And all of this tends to be rolled together somehow under the heading of immigration. And then you find talk is made. I don't talk of it, but there are those who always put together the word asylum seeker with the word bogus. And that creates a certain atmosphere. So, what I want to do today is to talk to you a bit about one particular part of this jigsaw. I want to talk about the Dublin III regulation and the geography of Europe and offer a reflection or two in the light of some current cases that are going through the court in which I have the challenge and the honour of being the Advocate General. But I think I probably need to start by talking to you a little bit about what the Dublin regulation, Dublin system is, because there is no good reason why you should be as familiar with it as I have now become. And I would put this under the heading of why, what, and how. First of all, the why. Why do we have a Dublin III regulation? Well, we actually started earlier with the Dublin Convention, then the Dublin II regulation. It wasn't the second regulation, but it followed the convention, so it became known by the nickname of Dublin II. And then we got Dublin III, because it was after Dublin II. Actually, when we are not talking shorthand, Dublin III is Regulation 562 of 2006. But why have we got it? Well, all the member states have the same international obligations under the Refugee Convention, under the Geneva Convention of 1951. And as you know, the European Union has a single external frontier, and a lot of the EU territory does not have internal borders because there is the Schengen area, and there's all the system under that, Schengen visa, Schengen border code, and so on. And as I've indicated, this is high-income area, it's peaceful, it's an attractive destination, both for persons seeking international protection and for economic migrants. Now, the member states decided, and it's not very surprising, they decided that it was in their collective interest to avoid having a situation where there were lots of third country nationals wandering around, crossing internal boundaries within the European Union, trying to choose the best destination in which to lodge their asylum application, and indeed sometimes lodging multiple applications in multiple member states, what goes under the rather unlovely name of forum shopping. For that reason, there was initially the Dublin Convention, then the Dublin II regulation, now the Dublin III regulation, and indeed there is talk of a Dublin IV regulation, because there is at the moment somewhere in the interstices of the Commission, there is a drafting committee and there's a proposal, and this is an ongoing process. So that's the why. Now the what. What the Dublin III regulation does is that it lays down a set of rules for determining a single member state that is going to be responsible for examining the substantive application for international protection lodged by any given individual. So, before you get on to looking at the actual application for asylum, you need to know which member state should be handling that. And that's what the Dublin III regulation does. It does the triage. It sorts out which application should be being looked at in which member state. The how. How does it do this? Well, it sets out a series of criteria for determining the member state responsible. And these are laid down in Chapter 3 of what is a very long regulation. I will try and keep this as non-complicated as I can. So, you've got Chapter 3, and Article 7 at the start of that chapter says the criteria are to be applied in accordance with the hierarchy that the chapter sets out, and which member state is responsible is determined on the basis of the situation obtaining when the applicant first lodged his or her application for international protection with a member state. So you take a photo at that moment, you look at the situation, and you decide which member state should be dealing with it. Now, at the top of the hierarchy are criteria relating to minors, children, right? That is Article 8. And then criteria relating to family members. That's in Articles 9, 10, and 11. Because it obviously makes sense to keep families together, broadly speaking. It's much more complicated as it's written in the regulation, but that's the basic idea. If you've got a member of a family in one place, it makes more sense to have other people who are in that family going to the same member state. Minors, family members. Next in the hierarchy, you have Article 12. Article 12 sets out the conditions for the criterion relating to the issue of residence documents or visas. Essentially what happens here is if you have a member state that is issued a residence document, they're responsible. If you have a member state which has issued a travel visa, they're responsible. Because there's a tie there, there's a link there to that particular member state. So that's the type of arrangement. By the way, in case you wonder, if a member state issued a visa on behalf of another member state, then it's the other member state that is responsible. And I say that because sometimes you do not have representation of all member states in all countries, which are third countries. So somebody who wanted a visa to go to a particular member state, might have had to get it through another member state. So far, so good. We now come to the criterion which, as a matter of empirical fact, is the criterion most often used. Excuse me, I do apologize. As you can hear, there's going to be coughs occasionally in this process, but I'm sorry they magnify quite so impressively. Next criterion, Article 13. Article 13 is entitled Entry and or Stay. And I'm going to read it to you because you need to understand, you need to keep this article in your mind for what's going to follow. Article 13, para 1 says, quotes, where it is established on the basis of proof or circumstantial evidence, and then it describes how you get that matter, I go back to the quotation, that an applicant has irregularly crossed the border into a member state by land, sea, or air, having come from a third country, the member state thus entered shall be responsible for examining the application for international protection. That responsibility shall cease 12 months after the date on which the irregular border crossing took place. So that's that criterion. There's a final, then there's visa waived entry. I'm just going through the list. There is a visa waived entry, which is Article 14. That is, if the member state said, you don't need a visa, come on in, then it's responsible. And the final one is Article 15, which is where people apply for international protection in an international transit area of an airport. Fine, you need to have a provision that deals with that, but that's not what we were going to be talking about now. I should also mention, it's important to mention this to understand the story, here is the list of criteria, but there is also a provision, and that is Article 17, which gives member states a discretion. I emphasize it's a discretion, it's not an obligation. Member states have a discretion under Article 17, para 1, to derogate from this triage system. And they can say, I am prepared to examine this application for international protection that has been lodged with me by this person, even if I were to apply the Chapter 3 criteria, I wouldn't be responsible. So a member state can always voluntarily decide that they will look at a particular application. That's the structure, that is the arrangement of the Dublin 3 criteria. What then happens, and again, I'm not going to drag you through all the detail, I can give you some references to opinions and you can enjoy yourselves. But what then happens is essentially this. If another member state is probably responsible for this particular person who's applying, then there are rules that govern how the member state is to request the other member state to take charge of that person. There are rules about accepting, there's rules about taking back, rules about transfers. There is also, importantly, there is a right to challenge a transfer decision. And that's to be found in Article 27, para 1, and that has been the subject already of some Grand Chamber case law of the court, because that was a development between Dublin 2 and Dublin 3, which increased access to justice and increased judicial protection. And there's big case law there. Okay, that's enough, that's quite enough, about how the Dublin system operates. So, now I've given you the necessary tools to understand how all of this bolts together. Let's move across to the geography of Europe. It's a lovely system. Now let's think about Europe. There's a more elaborate version of what I'm going to give you the case references, right? But there's a more elaborate version of what I'm going to summarize for you here, in my opinion, in one of the 2 pending Grand Chamber cases. It's the core of what I'm talking about today. It's actually 2 cases that are being looked at there. They're not officially joined, but one is case C490 of 16, which is the AS against Republic of Slovenia, I beg its pardon. Slovenia, I'm so sorry. I knew I'd do that, Slovenia. And the other case is case C646 of 16, and that case is Jafari, and that one comes from Austria. So, Slovenia and Austria. Let's look at our map of Europe. Imagine a map of Europe. I don't do PowerPoint, but I know you can all imagine a map of Europe, yeah? Imagine a map of Europe, and draw over the top of it a map of the European Union. Mark in the external frontiers. If you do that, there's some fairly obvious truths that emerge. If you look at, doing it your way around, the eastern edge of the map, there is an extended land frontier that borders 9 EU member states, running from north to south. As you go into the Balkans, the situation, a bit like the history, becomes a bit more complicated. But the important thing, I know there are people in the audience who know this my heart much better than I do, right? I see them smiling at me. So I'm not going to go into the great detail, but I am going to say the important thing to remember is you've got Turkey here and you have a land bridge that comes into the EU landmass coming across there. And of course, beyond Turkey, you have all possible routes from places where people may need to come from because there are problems at home, whether that be Afghanistan, whether that be Syria. Okay? Land bridge across into the European Union. Then you go along the south of the territory, and you have, of course, the Mediterranean, the cradle of civilization, lots of sea transit in the Mediterranean since ancient times. And if conditions in your homeland are sufficiently appalling to lead you to attempt the desperate venture of doing this, you can try to cross the Mediterranean in some kind of improvised craft. Not in a proper sailing boat, but in a leaking, inflatable, sinking vessel. So that's the southern border. So the eastern and the southeastern borders of the European Union are therefore potentially open to overland migration. The southern border is potentially open to migration across the Mediterranean. If you go on around the map, trying to do this right your way around, go around the map, you get the western edge of the European Union. And self-evidently, that is much less open to migration because you've got the Atlantic. You've got the whole Atlantic seaboard, yes, along the entire western edge of the territory. And if you make your way around the north, and for those of us who are sailors, it's great fun, except for the navigation, which is less fun, there is more sea. You've got the Irish Sea, you've got the Channel, you've got the North Sea, and then you have the bits of sea, Skagerrak, Kattegat, and the Baltic Sea. And so you've got a few land borders at the north, all right, with Sweden and obviously with Finland. But the short point is that whereas if you look at the east, the southeast, and the south, there are obvious routes coming in for migration. If you look at the west and the north, a mixture of geography and climate make migration significantly more difficult. That's the essential fact of the map of Europe. Now, the Dublin system that I described to you does not take the map of Europe as its starting point. The Dublin system tacitly, I do stress tacitly, it tacitly assumes that all applicants for international protection are going to arrive by air. They're going to land in the European territory, somewhere. And making a slightly heroic assumption here, if they were to do so, there would, in theory, be something closer to an equal chance that very roughly, equal numbers of applicants would arrive in each of the 28 member states. Now, I do say very roughly because one or other of you is going to say to me, well, hang on a minute, it does depend where the main airlines fly to and all of that. I'm going to say, yes, I know. But very roughly, if everyone arrives by air, there is a sort of chance that the distribution will be a little bit more even. Okay? And if you take that as the background, then the system put in place makes very reasonable sense. Because you look at where people arrive, you look at whether the frontier controls were in place, etc. Now, another essential element of the Dublin system is that it focuses on the individual applicant for international protection. It's that individual applicant whom you assess by reference to the Chapter 3 criteria in order to decide which member state's responsible. The whole regulation is focused on looking at the individual. And I'm going to say self-evidently, that is right, that is proper. Individual human beings seeking international protection are not statistics. They're human beings. They are to be treated humanely. they need to be treated with respect for their fundamental rights. In normal times, giving effect to this individual approach, which is enshrined in the Dublin III regulation, well, it may require administrative coordination between member states, with people sending forms across, you know, will you take this person? Oh yes, I suppose we better, yes, we'll take him. It requires administrative coordination, it requires cooperation between the competent authorities of different member states, but it does not present intrinsic or insurmountable difficulties. You get the system set up and you run the administrative machine and it works. That's in normal times. Between September 2015 and March 2016, and the problem hasn't exactly ended, but specifically between those two dates, the times were anything but normal. Not my words, what follows, but the words of the Vice President Timmermans of the European Communion, the way he described the root cause of the sudden, overwhelming migration towards the European Union. I quote, "There is a hell on earth. It is called Syria. The fact that millions of people try to flee from that hell is understandable. The fact that they try to stay as close to their home as possible is also understandable. And it is self-evident that they try to find safe shelter somewhere else if that does not work. More and more people are fleeing. The situation in neighboring countries offers little or sometimes no hope. So people look for a safe haven via Turkey, which shelters itself more than 2 million refugees, a safe haven in Europe. The problem will not solve itself. The influx of refugees will not stop as long as the war continues. Much has to be done to end this conflict, and the whole world will be involved. Meanwhile, says Vice President Timmermans, meanwhile, we have to make every effort to manage the flow of refugees, to offer people a safe place to stay in the region, in the EU, and in the rest of the world." End of quote. So what you then have is the following situation. You have very large numbers of Syrian displaced persons who join existing patterns. It's not a situation where there was no previous influx of refugees, people requesting international protection. But what happens is that the vast number of people fleeing Syria comes to add to the existing patterns. The patterns of people coming from other war-torn or famine-struck corners of the globe. For example, from Afghanistan, for example, from Iraq. There are two main routes. There is one route that got a lot of attention because the media understandably focused on the appalling maritime tragedies of overloaded, sinking inflatable boats trying to cross the Mediterranean and sinking during the summer months of 2015. And by the way, I say by the way, but it's not in any way an aside, 2016, same problem. 2017, this year already, many, many people have already died trying to cross the Mediterranean. And many have been rescued, and they're going to have to go somewhere. Now, that was one route. The Mediterranean is one route. The second major route is an overland migration route towards the European Union, which is known as the West Balkans route. And that route essentially involves a journey which is by sea and or by land. You go from Turkey, you go westwards to Greece, and you go into the Western Balkans, through the former Yugoslav Republic of Macedonia, Serbia, Croatia, Hungary, Slovenia. You maybe end up in Austria, you maybe end up in Germany, but that's the route, right? And lots of people came up through that route. Now, coming along that route by land, they didn't want to stay in the countries they were passing through. They wanted to go to where they were going to try and end up. So, in Austria and in Germany. By the way, those countries also didn't want all these people trudging through to stay put. So, for example, the former Yugoslav Republic of Macedonia and Serbia provided transport, which the individuals paid for, to take people through their country. And they allowed people using that route to cross into Croatia, particularly after the border with Hungary was closed. And then the Croatian authorities and the Slovenian authorities also provided transport, this time free of charge, and allowed the individuals to cross their respective borders towards Austria and Germany. And the policy of getting this vast number of people moving through was described, and providing free transport and so on, has been described as waving through, or the wave-through policy. So literally there at the frontier, instead of stopping people at the frontier, at the external border of the EU, the officials in their peak caps are saying, come along, please move along, madam. There's water there, bring your little girl. Yes, there's water there, and hurry up, please, there's a bus there. They're moving people through. They are not doing the stop at the frontier. May I see your passport? Where is your visa? Where is the proof that you have means of sustenance? It's just not that situation, right? And if you are interested in the history of how all of this then evolves, if you read the start of my opinion in A.S. and Jafari, you will find a description of the various steps that then happen, the fact that certain borders get closed, and so on. I'm going to say one thing here, and I say it with real sincerity. Bundeskanzlerin Angela Merkel showed extraordinary moral courage in saying that Germany would open its doors. It's not for me, I don't know, and I'm not going to speculate, whether she thought more people would follow suit or exactly what. But there were it was an immense act of moral courage, and a lot of people headed for Germany. Later on, it became clear, the more restrictions were introduced, and the situation, in short, becomes one in which you have an enormous number of people who have moved. By the end of October 2015, nearly 700,000 people had travelled along the Western Balkans route from Greece to Central Europe. Approximate daily arrivals, who really knows? There were some statistics for daily arrivals in Serbia, and people then moved on. Daily arrivals of 10,000 in October. Daily arrivals of 10,000 in October. What exactly, the sheer numbers, the sheer numbers we're talking about here are difficult to take in. If we look at this situation, late 2015 through to 2016, a front bit of 2016, in shorthand, that is described as the refugee crisis, the humanitarian crisis. In numerical terms, it was the greatest mass movement of persons across Europe since World War II. Please hold that fact in your minds as we move across and we look at the cases that are before the court. Because what then happens inevitably are situations in which the Dublin system is trying to operate, and authorities in one member state are making requests of another state. They crossed your border irregularly, you should take them back. In other words, the normal application of the Dublin system, normal application of Article 13, Para 1 of the Dublin III regulation. Cases that are currently before the Grand Chamber. There are two accelerated procedures and one priority. The two cases which are the one priority plus one accelerated procedure are AS and Jafari. AS is case 490 of 16, Jafari is case 646 of 16. Jafari is actually the accelerated procedure, the Austrian case, and AS, the Slovenian case, was in the system already, but since it raised the same issues, it was joined to the accelerated procedure. I think you say in English an expedited procedure, not an accelerated procedure. Sorry, I work in French so much of the time that I often find I've gone into franglais, which is not yet an official language of the European Union. So that's those two cases. And then there is another case, which is the Mengesteb case, which is case 670 of 16, and Mengesteb is a reference from Germany. To give you very, very briefly the basic facts of what's going on here, and again, the detail is obviously in the opinion, and it will be in the judgments in due course. The basic facts of AS and Jafari. Mr. AS is a Syrian, and he comes up through the Western Balkans route, and he arrives at the Slovenian border, and he goes as far as the Austrian border, then he comes back into Slovenia. He applies for international protection in Slovenia. Slovenia then says to Croatia, wait a minute, I think we should be returning him to you, Croatia. And then Croatia says, yes, okay, and there's a formal take-back request, which is accepted. So then the Slovenian Ministry of the Interior says to Mr. AS, we're not dealing with your application for international protection, you're going to be transferred to Croatia, and he challenges that. And the basic Article 13 argument is, well, Mr. AS came into Croatia as part of the wave through. That was an irregular crossing of the border. So that's Mr. AS. The Jafari cases. The Jafaris are sisters. They're Afghanis. They're two sisters, and both sisters have children. They fled from Afghanistan because their respective husbands have been taken by the Taliban and were required to fight in the Taliban's army. Husbands refused to do so and were killed. The father-in-laws of the sisters locked the women up, either for their own safety or because they thought that was the right thing to do. The ladies and their families managed to escape and flee from Afghanistan thanks to their father. The sisters fear that if they return to Afghanistan, they will be locked away again by their respective families, and they are also at risk of being stoned to death. Nobody, by the way, questions the credibility of the story so far. This is an argument about which member state should be processing the application, but everything in the order for reference that's there does not cast doubt on the basic underlying story. These are real human beings who really need international protection. So, the Jafari families leave Afghanistan. Inevitably, there's a people trafficker involved. They come through, they travel via Iran to Turkey to Greece. Then they go back out into the former Republic of Macedonia, Yugoslav Republic of Macedonia, Serbia, Croatia, Slovenia, and they end up in Austria. And they apply for international protection in Austria, and Austria says, no, we think that these people should be being processed in Croatia because they crossed the Croatian frontier on the way through. That is where we stand on the facts. And so the court gets these cases, very long, elaborate questions, asking about how you apply the Dublin 3 regulation in these circumstances. That's AS Jafari, those two cases. Mengesteb is case C670 of 16, as I said. Mr. Mengesteb is an Eritrean, and he entered Italian territory by crossing the Mediterranean from Libya. We do not have any facts as to how he actually made the crossing. We, the court in Luxembourg. There must be some facts somewhere, but we don't have them. We know that he got to Italy, then he goes to Germany, having travelled overland. The German authorities provide him with various documents. There's a long pause because they're overwhelmed for processing applications. There's a big gap between when he gets his first piece of paper saying he can claim certain basic matters like housing and food. Then he finally puts in his formal application, I think about 8 months later from memory. And at that stage, the German authorities check, yes, there's a Eurodac, a fingerprints record in Italy, so they ask Italy, they say, you're the responsible member state. And he challenges that, and he says, no, you know, we've all run out of time, Germany should be doing it. That's the Mengested case. Those are the basic issues. So these issues, these cases, the two opinions are out. The cases are both en délibéré at the moment. The court is working on them. All three cases involve the issue of Article 13, this irregular crossing of the frontier. A.S. Jafari expressly and directly, but Mengested also, because there's an assumption that Mr. Mengested should be transferred to Italy, and that he should be transferred to Italy because he must have crossed the Italian frontier in an irregular fashion. That's the premise behind everything that's asked in Mengested, is the arrival in EU territory in Italy was irregular. And Article 13, is the criterion most frequently used in these take-back requests. So, you know, let's just look for a moment or two a little harder at that issue. Because it seems to me that there is a rationale for what happens in normal times, and then you ask yourself a little bit whether that can really be applied across to what happens here. I preface everything I'm going to say by saying I have no idea what the court is going to do with these cases, because they are not easy cases. Normally, you do say if the person crosses an EU border, an external border, in a manner that does not comply with the border code, that automatically triggers consequences within the Dublin scheme. That's the normal situation. I will also say there's a problem with the text because some of the texts refer to an illegally crossed border, some speak of an irregularly crossed border. We have the usual linguistic soup that is going on here. So please do not get too interested in whether the word is illegal or irregular, because it's not going to help you to understand the problem. The linguistic difficulties are not really what this is about. Now, normally speaking, in a normal and sensible and rational world, there are excellent reasons why Article 13.1 exists. Effectively, its aim is to encourage member states to be vigilant. They are meant, on everyone's behalf, to guarantee the integrity of the EU external border. If they're doing their job, people do not cross irregularly, and we don't have a problem. So that, you know, if they do let their guard down and people cross, then they should be responsible for looking at the application. And Article 13 also aims to discourage secondary movements of people, discourage border shopping. You know, all very good, all very sensible. In normal circumstances, you apply it, somebody enters the territory of the European Union by subterfuge or by some clandestine means, they manage to sneak across the border. And the entry, the subsequent stay, are clearly irregular. The entry, there's a set of rules they should have been complied with, and they weren't complied with. The member state should have been more vigilant. It's not that the member state condoned the border crossing, it's just it failed to stop the border crossing, so you know, if they'd been more vigilant, the person wouldn't have got into EU territory. That's the basic rationale behind Article 13.1. That's totally logical. Now let's look at what we're actually looking at here. Let's return to the humanitarian crisis which occurred in this period. And I make no apology for quoting from what I put in the opinion, because I'm not going to state it better if I try to do it again for you now. What I said in the opinion was this: there is a human flood of desperate people, those fleeing the war in Syria, swelling the numbers of those who have trekked from Iraq or Afghanistan. They sweep up to the Croatian border post in their hundreds, their thousands. They have little or nothing with them. If they are kept out, they will somehow make improvised camps with international assistance, as and when it's forthcoming, from bodies such as UNHCR, the Red Cross, and Médecins Sans Frontières. Those will help to feed, shelter, and care for them. There will be a humanitarian crisis on the European Union's doorstep. There is an obvious risk the neighbouring states, the Balkan states, will be destabilised, creating a real danger to peace and security in the region. Winter is coming on. And the basic point behind this is, this is geography. It's not choice. It's geography that dictates which member states are in the front line. Those member states have international obligations, humanitarian obligations. They should let people across the frontier, but if they let everyone across the frontier and hang on to them, they can't look after them. There's just too many. And if we send everyone back to those member states and ask those member states to process the applications, well, they can't do it. Croatia has, in round figures, maybe 4 million people. How is it meant to look after 500,000 asylum seekers? It doesn't add up. So much for the West Balkans route. By the way, one can make very similar statements in relation to the Mediterranean route. And you can say it's okay if somebody gets off a boat and manages to disappear somewhere in the coast, up the coast, that's an irregular border crossing. Is it really an irregular border crossing when people wearing life jackets are pulled out of the sea because the leaking inflatable on which they were travelling has sunk beneath the waves? And here, again, I paraphrase, all the material is sitting in the Member State opinion, but there are very big international obligations about rescue at sea. I speak as a sailor. It's one of the things you learn very early on, that you are under an obligation, if there is a situation at sea where there is danger to life, any vessel in the area is under an obligation to render assistance. It's one of the oldest rules of the law of the sea. And you find it in the UN Convention on the Law of the Sea. You find it also on the Convention on Saving of Life at Sea. You find it in the Search and Rescue Convention. There's lots of international law there that says you rescue people whose lives are in danger at sea. And you take them to a place of safety. Now, there is not actually a corresponding matching obligation on the coastal state to take them in. But what in fact happens is that these rescues tend to be landed in Italy, because that's where it's the nearest place to take your hundreds of dripping wet people wearing survival blankets. It's the nearest place to take them to. So that's, that is the background, and that is the basic problem. And that's the problem that the court, remember it's a court of law, that's the problem the court is looking at in these cases. In Jafari, it has to step in and answer the question, how do we interpret Article 13.1 of the Dublin III regulation? In Mengestebe, you can sort of turn a blind eye to it because it wasn't actually asked by the National Court, but the underlying issue is plainly there. And so in the short term, the court is essentially being asked to do a retrofit of the Dublin III regulation to a situation which nobody had in mind when they wrote the text of the legal instrument. And the court has to step in and do something. And I am certain that whatever answer it gives is going to be unsatisfactory, at least from some perspectives. I know, as the Advocate General in both those cases, those three cases, AS, Jafari, Mengistu, as the Advocate General, I have, in about equal terms, already received praise and obloquy, depending on who was talking to me and what their particular background was and where they were coming from. And I am sure that whatever the Grand Chamber of the Court does with these cases, there will be some people who say it's a good decision and other people who say it's a lousy decision. And actually, this is not something that the court should be trying to resolve. In the longer term, we need a political and/or legislative solution. Now, here I need to be, and I'm going to be, very careful. I'm not saying that the member states must do precisely A or precisely B. It is for those with political and democratic responsibility to choose what they're going to do. There are some obvious components that one might wish to look at. Whether that's what gets put in place, I have no idea, and it is not a decision that I am or should be involved in. But there are some obvious components. One of the obvious components is more solidarity between member states, sharing out the applications, but you'd need to revise Dublin III, or you'd need a new instrument, you'd need to sort that one. Another issue that maybe one should be thinking about is addressing the causes of destabilization in neighboring areas. One might think that it was necessary to think about taking some kind of concerted action to crack down on people traffickers. That's why people get onto leaking inflatable boats, is that people take money off desperate people and put them onto the boats and give them the telephone numbers of the search and rescue people, so that as soon as they're out of territorial waters, they phone up and say, please come and get us because this boat is going down. Such concerted action would obviously have to be done with the permission of other sovereign states, and it would have to be done in cooperation with them. One idea that I've heard floated would be to set up points for dealing with asylum applications before people ever arrive on EU territory. Something a bit like the Sanghetti system that exists in relation to immigration control, where in the immigration control for the UK, in fact, happens in France before people ever cross the Channel. And if that route were followed, then if the application were accepted, then there might perhaps be help with the transfer and with settlement. And if the application were rejected, well, the person would be fully documented and they would be discouraged from useless further travel. But of course, if you create that sort of a system, it requires a lot of cooperation. It also requires having some kind of judicial supervision or right of appeal, because there is no such thing as a system which only makes correct administrative decisions. I speak with the perspective of somebody who was 25 years in practice. The administrative system that never makes mistakes has yet to be created. But I mean, everything I've just described to you requires resources and collaboration and cooperation and solidarity. And another component, another obvious component, help with aid, help with development, help with disaster relief, so that people don't have to move in the first place. Now, everything I've said to you, I'm not saying how that this should be put together. What I am saying is that at the moment, the court is doing an answer to specific questions referred by national courts. That is our job. But the job of working out what to do with this situation is the job of the member states and those who have political and democratic responsibility. And that needs to be addressed. It is a big challenge for the European Union. I'm going to finish, I hope more or less on the right timing, I'm going to finish with the following observation. When you see pictures of refugees, they really are out of luck. They have nothing. And they have to take, they have to receive from other people's generosity and humanity. That is what being a refugee is about. You arrive with the very little that you manage to bring with you, perhaps with the nothing that you manage to bring with you. And so these incomers initially need to ask from society. If they are well received, and if they are helped, and if they are bright and industrious and work hard and integrate, they or their descendants may end up giving back to society. I know there are a few bad apples in the barrel. I know that sometimes you have people who come in who are undesirable and remain undesirable. But you also have a lot of people who come in and who end up being very hardworking and responsible members of society. And I would say, and I can assure you, there are at least 2 examples. You may even end up with people who are descendants of refugees who become serving members of the Court of Justice of the European Union. Thank you very much.
Questions? Oh, thank you, Fernanda. Who's going to start?
Thank you for your presentation. I wanted to ask you, if I'm not mistaken, a huge amount of money was granted to the Turkish government to handle with the refugee crisis. And I wanted to know if the use of this money was controlled by the European Union, since we know that that there are a lot of human rights violations in this country right now. So I just wanted to know.
I don't know the answer to your question because I do not know the terms on which it was given or whether any kind of control of any kind was put in place. I mean, I would point out that giving money to a sovereign state, it's a little difficult to sort of put in place an exact control. Turkey is not part of the EU. They don't come under the jurisdiction of this court. Often the controls are not legal controls. They're simply that you have a situation in which a deal is struck and both sides want something out of the deal, and therefore both sides have an incentive to keep to the terms of it. That's not a lawyer's answer. That's in sense of a very precise legal answer. It is a working barrister's answer that there are many deals which are struck and which, if you really tried to unpick them legally, you'd wonder where you got to, but the simple fact is that on the whole they work. It's a very fair question, but I have no very useful answer to give to it.
Thank you for your lecture. There are further 2 more pending applications from Slovakia and Hungary.
Sorry, can you speak a bit slower, because we've got quite a big echo and I'm half deaf, so I'm trying to hear you. Sorry.
There are two more applications now pending before the Court of Justice from Slovakia and Hungary. Yves Bott is going to deliver his opinion, I guess, on the 26th and the 27th, and they concern a derogation from Dublin 3, if I'm correct, about the relocation of 120,000 refugees. One of the contested things with this application is that it was decided by council decision in a non-legislative procedure, and it is a derogation to a legislative act. So that was the main kind of thing that we contested. And in your lecture, you emphasized the need for legislative action as compared to something that we impose on the member states. But these circumstances are extraordinary, as you said, and solidarity is needed, but solidarity sometimes lacks in these countries. So where is the result? How can we achieve this through legislative procedure?
I can't tell you, because first of all, I think that these circumstances are extraordinary. And I have tried, in the way that I wrote the opinion, I have tried to highlight the elements which seem to me to make the circumstances extraordinary, and I have tried, if you like, to persuade the court that these circumstances are extraordinary. When you've said all of that, we have a text, all right? The court has a text that it's trying to interpret. And the court can only go so far within the parameters that it has, namely the law that is written down, to trying to produce answers. And at a certain moment, the court both can and I think probably will pass the problem back, because we are not in a position, we don't unfortunately have a magic wand. Yeah? We are not in a position either to foresee all the problems or to solve them. If I look at the way the mechanism works on the references between the National Court and the Court of Justice, it is the National Court which deals with all the facts. It's also the National Court which is going to take the answer that we give and apply it to the case before the National Court. All that we do, and sometimes the all is nevertheless quite a lot, all that we do is we try to help the National Court by answering the question of interpretation or validity of EU law that's put to us. Now, if it is very obvious from the facts that we already have what the answer should be, we may indeed give the National Court a hint and say, look, of course it's entirely a matter for you, but look, we've looked at this, we've looked at this, we've looked at this. It looks to us as though that is the answer. More often, and perhaps this is particularly true when the problem is a difficult one and we realize that we don't have all the material, we take what we've got, we try to outline what the principles are that the National Court should be applying, and then we hand it back to the National Court. Now, it may very well be that when we do that, the National Court, for example, needs to take more evidence. They need to find out more. Maybe there are aspects of the problem that become more evident from the answer that we give. And then the National Court will need to take evidence on that and reach a decision. But very often, I know that, how can I put this? It's a great honor to serve in a Supreme Court. It's a very great honor. But actually, we are there to work with and to help the national courts. And it is the national courts who are in the front line, who are dealing with the issues of EU law. They ask us for interpretation, but it is they who are the judges of the individual cases and who have to deal with them.
Can I just, I'm just abusing my position here.
Not at all, go for it.
It's going back to this question of interpretation, and could you just say something how you approach, in your opinions, this question of, you were talking about this being an exceptional situation. So would your line of reasoning be more, this is not a case of irregular entry because of the wave through?
I say it's not irregular entry.
So one could say, yeah, we can't really operate on the system of irregular entry because of, as you were saying, there's a humanitarian disaster, and therefore the normal system cannot apply. So, but you're seeking to, in a way, square the circle by saying, well, we can apply the normal system, but we just interpret it in such a way as to say this is not an irregular entry. But there's a fine line between the two, isn't there?
It's a very fine line, dear Professor Cremona, and I do not know whether the Grand Chamber would like to follow the fine line that the Advocate General suggested. You were very kind earlier in saying that I wrote persuasive opinions. I don't know if I've been persuasive enough in these cases. I should have said, but I was trying to keep within the boundaries of time, that there is a provision in the Schengen Border Code, it's one of the sub-paragraphs of Article 5, which allows a member state to permit entry into its territory in order to comply with international obligations or for humanitarian reasons. And so the structure if you take the Schengen border, you understand why I didn't try and make an already complicated lecture more complicated. If you take the Schengen border code with the Dublin III regulation, all right, and you mesh the two together, you can say, this isn't a normal, quotes, irregular entry under Article 13 of the Dublin III regulation. But it's not the sort of entry that is envisaged, as in an entry with full documents and stamps in passport and so on. I mean, ask yourself the question, you've got all these people filing up to the border. How is the border guard going to stamp everyone's document? Forget it, it's not going to happen, right? So the normal system, even if the border guard is under pressure, he's meant to stamp all the documents. He's not going to do that. But there is a provision in the Schengen Border Code which allows a member state to authorize entry onto its territory, and if the entry is authorized, then it's not irregular, is it? For humanitarian reasons or to comply with international law. If you use that route, then you say, well, the entry into Croatia wasn't an irregular entry, and indeed nor was the entry into Slovenia an irregular entry. And so you then end up, having gone through the list of your Dublin III criteria in Chapter 3, you end up with the conclusion that the member state where the person ended up is the member state which should be processing the application for international protection. Now, I mean, I do emphasize, I'm not trying, and nor is the court I serve, trying to decide the individual case. What we're trying to do is to give the national judge guidance. And one of the reasons why these cases were expedited is that the national judges in both Austria and Germany made it abundantly clear to us that there are thousands of applications sitting in the system, and that the guidance that we give for these cases will be relevant, may not be determinative, but will be relevant for deciding those cases. That is why the court expedited these cases. It's also how I ended up writing two such enormous opinions very close to each other, right? Normally it doesn't work quite like that, but never mind. That guidance will need to be applied to the individual cases. It may be in particular individual cases that route, that way of looking at things is correct. It may be that on evidence that's not so in other cases. I should have mentioned, if I was giving a more complete answer, that there's two lists in the implementing regulation of the type of evidence that shows where somebody crossed a border. One of the most telling types of evidence is evidence via Eurodac, is the fingerprint database, right? So if you have fingerprint evidence that somebody was in a particular member state, unless that evidence is displaced, that will usually be strong evidence that that is the member state that should be dealing with the application. And so on, and so on. As I give you more detail, you see that this, each individual case you're going to have to look at what the file says and whether the decision is robust.
I have the microphone, so I can make the question. Well, from before.
The man with the microphone has the power. Sir.
Well, thank you so much for the lecture, and I would like to ask something that maybe is not connected with the legal aspect, but more with the political aspect, because this situation has a lot of things to do with politics, with how the norms are created and when are created. And you point in your presentation that geographically, the regulation doesn't take into account that, But what I want to ask you is, it was made in the correct moment to manage the extraordinary situation, because let's remember that in the 90s there were conflicts. There were conflicts far away from Europe, where Europe and some member states, they participate, for example, Rwanda, and there were hundreds of thousands of refugees. But it was on the countries that they were around Rwanda. I mean, it was Uganda, Zaire, Tanzania, but the public opinion didn't know it. I mean, they were focusing on other things. But then after, remember the Balkans and Kosovo and Albania and the thousands of people that were also refugees. So when it was Dublin 2, Dublin 3, it was now in Syria, and when it affected to the central part of Europe. So I think it's a little bit a lack of coherence in all this system still. What's your opinion in this? Thank you.
I think you have given us a very valuable and important reminder and lesson in European history. But it's also the history of many other places that you only grapple with the problem when it is on your doorstep. When the problem is happening somewhere else, you say, it's very sad, it's very shocking. Perhaps I will send some money to Médecins Sans Frontières. But you don't deal with the problem. Here the problem is not only on our doorstep, it's in our own house, because people are here, they have arrived. They are physically in the territory of the European Union, they have got here. And people therefore member states, administrations, therefore have to deal with the situation. But I think that what you have reminded us of, and it's very valuable that you do so, links directly through to what I was saying towards the end, that it is important for those who have the political and the democratic responsibility to try to look beyond the immediate, here are these people at our doorstep, and ask themselves the question, why do these things happen? Why do people move? People do not move lightly. My own family was in Lithuania, and it's not that long ago. My father's mother came as a refugee to the United Kingdom. There were many people in the family who did not move, because moving, it's a lot of trouble, you know. You are settled somewhere, you have your friends, your family, you grew up there, you know the place. The journey is difficult, it's dangerous, it's going to cost money. And then when you go somewhere, what is it going to be like? You don't know the language, it's going to be different temperature, different climate. What will you do? How will you work? Moving is not an easy decision, but it does depend on what the surrounding conditions are. If the surrounding conditions are ones which you think, I am not going to go on living here and bringing up my family here, then you will move. And that is what needs to be borne in mind. And again, I go back to the beginning of what I was saying. The more successful we are with the European project that I, for one, am very proud of, with the prosperity, with the peacefulness, with the comfortable lives that we are creating on the whole, you know, compared to many other places, with the comfortable lives we are creating for the citizens of Europe, the more we are successful in doing that, the more the EU area is going to serve as a magnet. And we are in a world in which there is international communication. It's not sailing ships and letters that take 3 months, if you send a letter. It is a world in which there is access to internet. There are people who talk on FaceTime with friends back home. There are, you know, there's somebody who's got a mobile phone, there's somebody who's got a means of communication, and there are pictures. We are in a world in which people know or think they know. You know, the streets may not be paved with gold. Actually, if you arrive in Europe, you may find that it's not all golden. But if the picture that you have is that it's golden, and there's a disaster happening at home, you're going to try and move. And you're going to scrape together the money to pay a people trafficker. You're going to borrow the money, even if it's going to take you the next 10 years working to send the money back round through your family to pay off the loan. You're going to do it. And then this one. At the front first, and then at the back. Please.
Thank you again for the lecture. It's really an honor to have you here. So I have a rather sensitive question, comment, and asking your opinion about it, since you know, as a person living in Brussels and experiencing the terrible events on the 22nd of March last year. I just wanted to ask your opinion. How should the rule of law maybe try to strike the balance between, you know, the European asylum policy, because I don't think that all the people coming from those countries and running away and trying to save their lives should be blamed for what's happening with, you know, with the terrorist troubles. But how should Europe strike the right balance between EU asylum policy on the one hand and the safety and the lives and the values of Europe on the other side? And do you think somehow EU should work on, I don't know, increasing the importance of defense policy? And it's, I know it's a complicated question, but and sensitive, but what do you think about it? Thank you.
It is a complicated question. It is a very important question. I want to try to disentangle some of the strands within the question, because it seems to me that it is very easy, inadvertently, to put things together which in fact belong apart. One question is our international obligations, our obligations, all the member states' obligations, under international law to grant international protection to people who qualify for international protection. That is one story, and that is the right to asylum and international protection. Within that law, there are also exceptions. People do not qualify for asylum if, in fact, they are people who have already committed major crime or who are going to come, you know, they don't qualify, right? That's one story. Another issue is how you keep people safe against threats from those who do not share the same values and who actively wish to destroy those values. And there, it's not actually right to think of it just in terms of people who are seeking asylum, because that's not actually, it's not the whole problem, it's probably not even the problem. Because there are many, if you look at the backgrounds, as far as we know, to, you mentioned the attack in Brussels, but you could equally have, you could mention Nice, you could mention Paris, you could mention London and Manchester, you could mention many, right? If you look at what is happening, it is simply not right to say that the problem is always an asylum seeker. The problem is often not an asylum seeker. The problem is often somebody who is a young person who has become radicalized. But the young person is not necessarily an asylum seeker. They may be somebody who was born and bred in Manchester. So it is wrong to make that connection. It's a connection that is very easily made by certain parts of the popular press, but it is not logically a correct connection based on the evidence that we have. And I'm going to add a third element to this because I believe it to be vitally important to remember this. And I speak as somebody who used to do EU law cases for 25 years, very often for the government, but I did many human rights cases against the government pro bono. So that's my background, so, you know, understand my background, that usually colors what people are going to say. I am going to say that part of the rule of law is respecting fundamental rights, and I am going to say that fundamental rights are not there to protect people we like. People we like do not need to have their rights protected because their rights are not usually violated. The test of fundamental rights and the test of a civilized society under the rule of law is whether it is prepared to uphold the rule of law and fundamental rights even for people whom the popular press is saying we shouldn't like these people, or even for people who are suspected of committing offenses which are very repugnant to society and which are evil and nasty, and we do not agree at all with that, but we still think that the fundamental rights are important because they are the hallmark of a civilized society under the rule of law. Here are three different strands, right? We have to work out how we deal with each of those elements. But we need to avoid letting them get into a kind of tangle so that we don't think through the individual pathways there. Okay? I can't hear a word.
No? Thank you. Thanks very much for the very interesting lecture. I noted one of the aspects you mentioned about the difficulty of retrofitting the Dublin 3 regulation to the current scenario, and it brought me back to some of the lessons in constitutional law and trying to understand the relationship with the issue of judicial activism and how you would face the challenge and how you think the court will face the challenge of and how ambitious the court will be in finding a creative solution to this interpretation to balance on the one hand the humanitarian requirements and on the other hand the unambitious nature of the Dublin 3 regulation and the unsuitability of it to the current situation. Do you have a feeling how you approach this yourself, where to draw the line where one is being perhaps too active in finding a creative solution within the court? And what is your feeling as to how the Court of Justice at the moment in its current composition approaches this issue, if it's an ambitious court or not?
I have no idea what the Grand Chamber is going to do in AS and Jafari and Mingastape. I think I can be confident in predicting that the judgments that the Grand Chamber will write will be less extensive in trying to look at the problem than this Advocate General was in her opinions. That is a reflection of the difference in function between the Advocate General and the reporting judge of the court and the formation of judgment. Because the Advocate General, if he or she is doing his job, as I would say correctly, the Advocate General goes out there and tries to look at the broad issues, tries to highlight the parameters, the components that need to come into the decision, looks at various options, and then makes a recommendation. That's the job of the Advocate General. And in doing that job, the Advocate General has a big advantage. You're one person. Major, major advantage. You're one person, you're independent. It may be appallingly difficult to make up your own mind as to what you're going to say and exactly how you're going to say it. But once you have made up your mind, you do not then have to get the agreement of everyone else in the room. All right, that's a big advantage. The court is a composite body drafting committee draftsmen and then contributions from other people, operating, if possible, by consensus, because the judges have to deal with each other day in, day out, this week, next month, in 3 months' time. So you have to find a compromise text within the deliberate that people can live with. And that process involves negotiation. I speak as a former referendaire for a judge, right? So I do know a little bit what I'm talking about here. I'm no part of the deliberate, I'm not part of this. But from my previous work, I do know a little bit about how this happens. You have to negotiate, and what happens is sometimes that some of the sharp edges come off, that you remove a paragraph or two that are causing trouble, maybe you put something in its place, maybe you don't. You end up with a text that people are prepared to sign up to. Very often, you end up with a text which is, in a sense, minimalist. It says the least possible that is needed to get to the answer. And if that means that some questions don't get answered, well, from the perspective of the judge sitting in the deliberate, actually that's just as well, because you don't know enough to answer all the questions, nor did the Advocate General, by the way. You don't know enough to answer all the questions, and you do not wish to commit the court in a binding ruling to saying more in this case than it has to say in order to deal with this case. And so I am fairly confident, for example, in predicting that in Mengestebe, the court is not going to try to deal with the question of whether people who cross the Mediterranean are or are not illegally entering the EU when they land in Italy, and if so, under what circumstances. I flagged the problem for the court. I said at the beginning of my analysis, I said, look, excuse me, there is a big elephant in the room. It's breathing down the back of our necks. It's right there. Here is the elephant. I also said to the court, we don't have enough material in this case to look the elephant in the face and deal with it. We don't have the material because the national court did not ask us a question about the elephant. Because the national court did not ask us a question about the elephant, the member states did not lodge observations about the elephant. Nobody, until the Advocate General spoke about the elephant, nobody spoke about the elephant. The court is not going to deal with the elephant. Nevertheless, it was the job of the Advocate General, at least as I see it, to alert the court to the fact that the elephant is standing there in the room. And that sooner or later, somebody, preferably the member states, preferably the legislator, will deal with the elephant. Because it would be much better that the legislator did deal with the elephant. It is not desirable to have problems that are real problems involving big political choices that end up being dealt with by the court in the course of a reference because the member states have not addressed the problem. That's not a good solution. The court will have to give an answer to the member states' court that sends a question, because that's our job. But it is infinitely better if the member states realize there is a problem that needs addressing and they deal with the problem, because they have the democratic legitimacy to do so. Next time somebody says to you that the Court of Justice always insists on overstepping the boundaries of what it should do judicially, please remember this. Remember what I just said, yeah? Microphone. There's also a microphone at the back. Somebody's got a mic there. Yeah.
Sorry, if you allow me, I would make a 10-second consideration on a unique situation within the EU. A unique situation within the EU, which is the situation in Cyprus. Because though it's from the southern border that you were talking about, it's not so affected by refugees as Italy. And it's a political choice because it's an island. People don't want to go in Cyprus and stay in Cyprus. They want to go in the northern part of Europe. Nevertheless, there are two elements that are unique. One is that there is an area that is not under control of the government of Cyprus, which is the northern part of the island, where there are movement of people coming from Turkey regularly through airplane, and then they slowly cross in the southern part. And politically, the Republic of Cyprus is not very keen to deal with this and understand them as proper refugees. So that this one could be a situation that may arise in future. The other situation is also related more with the general course that we're having, is that in Cyprus, as you all know, there are two British sovereign areas, and technically those are UK territory. Now, currently there is an agreement between UK and the Republic of Cyprus for accommodating this. I'm quite suspicious that this will not work once the Brexit is finalized, if it's finalized. And the UK authority has been very creative in accommodating previous refugees who landed there. As you may know, there is even a court case who just was decided.
Sorry, as I may know?
There was a court case before the laws, which was decided.
Recognition of judgment, yeah.
Exactly. And because there were some Kurds family since '98 still there, not allowed to move, and there is no border the sovereign area are not, there is not a proper border, so people can easily move. And there has been last year already some boat who wreck in this area and has made a lot of noise. So I'm saying that these may be two situations that may one day reach even the court. So
I agree with you, they may be.
I'm going to take this. I'm going to take your question and allow the Advocate General to answer to both, and then we're going to have to stop because you need to have a little break before the next class, and you've been standing up for long enough. So let's hear from
Thank you. First of all, thank you very much. I want to come back to the agreement or deal which has been struck between Turkey and the member states of the European Union. In your opinion, does there exist any jurisdiction of the Court of Justice of the European Union towards concerning this agreement or deal? Because there has been, I think, a decision of the General Court in which which was concerning an action for annulment, and where the General Court has rejected any jurisdiction about this particular agreement. Thank you.
As far as I recall, that case is on appeal, and it would therefore be entirely inappropriate for me to comment. Did you have one? You have a lady there who's begging for the microphone, please.
Just a quick one.
Go on.
Thank you very much. I would like to wonder, when you are doing your opinion in these cases, that your opinion in of the last month, have you thought about the possibility to use human rights, as like it was in the NS case against UK and Greece, to try to create another system of allocation?
Well, I'm very pleased actually that you mentioned the NS case, because part of this equation is that the West Balkans route leads first into Greece, at least normally it leads first into Greece. But because of the amount of pressure that has already been on Greece, Greece is not a place to which at the moment people get returned under Dublin III. And one of the elements that I did mention, I mean, I'm sorry, they are big opinions and I don't want to sort of seem big-headed by reading them out to you, but one of the elements that I mentioned in the A.S. Jafari opinion was that if you have a situation in which, so to speak, you push people back to Croatia as the point where they cross the border, and you do so irrespective of the number of people concerned, there must at least potentially be a risk that what happened with Greece then becomes the situation in Croatia, that they simply cannot cope with the number of people that are there. And then you have that situation. I'm speaking now, you understand, hypothetically. I'm not saying this has happened, but it's a potential, it's a possibility, it's a potential problem. That if you ignore the geography and you just push people back to the point of entry, gradually you have a situation, Greece already, maybe Croatia, maybe Italy, maybe Slovenia, maybe, because you push all the people back to certain states, you make it impossible for them to cope, and then they can't take people. And you haven't actually solved the problem. You've just created more difficulties. And that's where the human rights element partly comes into it. Because as you will recall in NS, that was precisely why the claimant in NS could not be returned. Yes? And clearly, it is not in our interest as a European Union, which is proud of trying to respect fundamental rights, that we operate matters in a way which make it more difficult for more member states to respect fundamental rights. That's not where we, as it were, not where we want to go. And that element did come into the story. But there is a difference between what I do as Advocate General and what I used to do as an advocate, yes? As an advocate, if I had been acting as an advocate for some of these applicants, of course, when you're acting as an advocate, you look at the argument you can raise under EU law, but you also look at any argument you can raise under the ECHR. And then you try to put together the best case you can for your client. Although my title is Advocate General, I wear a slightly different hat these days.
Thank you very much indeed, Eleanor, Advocate General. That was a wonderful lecture and a great exchange of questions and answers at the end. Thank you so much.
Thank you for the questions. Thank you.